Everyone. It's great to see you all. Welcome to the inaugural academic year 2020-21 Diversity and Legal Thought and Practice Speaker Series at UC Hastings. This is sponsored by the Diversity, Equity, and Inclusion Working Group at UC Hastings and the Center for Racial and Economic Justice. I am delighted to welcome today's speaker, Anansi Wilson, an adjunct professor and Center for Racial and Economic Justice affiliated scholar. Professor Wilson is an award-winning scholar of law, literary and cultural studies, a racial justice strategist, and an author of creative nonfiction. Their legal research is situated in legal philosophy, critical theory, political economy, Black studies, and constitutional law. Their writing and scholarship primarily focus on the history of Black thought, art, and imagination, crafted in response to and resistance of the social, political, and legal realities of domination in the West. They seek to understand the process and processes of retrenchment after movements of social progress, and to understand how freedom dreams are nevertheless sustained. Professor Wilson will discuss two of their most recent articles today. After they present, we will open to the floor for questions. I'm sure there will be a lot of questions, and to give us the most time to hear from audience members, I just respectfully ask that persons posing questions be brief and avoid long narrative statements. Please note too that this event is being recorded and that we intend to disseminate the recording. Without further ado, Professor Wilson.
Hello, good afternoon on the West Coast or wherever you are right now, and thank you for your time and listening to this talk. So the title of the pieces are Furtive Blackness on Blackness and Being, as well as the strict scrutiny of Black and Black queer life. I'm not going to go deeply through the papers because I want to spend as much time in conversation with everyone here. But what I would like to do is begin, as I usually do, with a poem that will kind of contextualize what it is that we're beginning to be talking about. And after that, I'll have a PowerPoint that I'll kind of zoom through again so we can have a deeper discussion rather than me lecturing at you. Let me just pull this up 1 second here. The title of this poem is The Occupied Territories. It is by Essex Hemphill, one of the leading Black queer scholars and organizers of the 1990s. It reads, "You are not to touch yourself in any way or be familiar with ecstasy. You are not to touch anyone of your own sex or outside of your race and then talk about it, photograph it, write it down in explicit details, or paint it red, orange, blue, or dance because it is yours. You are not to touch other flesh without a police permit. You have no privacy. The state wants to seize your bed and sleep with you. The state wants to control your sexuality, your birth rate, your passion. The message is clear. Your penis, your vagina, your testicles, your womb, your anus, your orgasm, these things belong to the state. You are not allowed to touch yourself or be familiar with ecstasy. The erogenous zones are not to be demilitarized. And I read this poem to put in context the type of work that I'm trying to do. This work, in kind of the words of Christina Sharp, and I'll read a quote in a moment, is attempting to try to articulate a method of encountering a past that is not past, a method along the lines of a sitting with, a gathering, and a tracking of phenomenon that disproportionately and devastatingly affect Black peoples any and everywhere we are. Sharp says, I'm interested in plotting, mapping, and collecting the archives of the everyday of Black imminence and imminent death, and in tracking the ways that we resist, rupture, and disrupt the imminence and imminence aesthetically and materially. So what I'm attempting to do right now with this talk and with both of these papers is account a type of counter jurisprudence, a type of counter precedent that instead of just looking at the Constitution and the law as we know it as fact and truth and given narrative, I want to begin to think about the law from the side of the Black and Black queer body, not from the beginning of slavery per se itself, but from the moment of 1619 when the first Black body, the first Black being arrived on these shores. If we were begin to kind of analyze law itself, right, from these beginning moments of knowing, of terror, of rape, of dishonesty, and this kind of double speak, how then would we consider this reasonable person? Who would this reasonable person be? How then might we consider notions of equity, particularly as we're talking about the 14th Amendment? So when I begin to talk about this notion of furtive Blackness, I'm thinking about the Black person, the Black body itself, as an embodied furtive gesture. The term furtive, usually in legal parlance, is talking about this kind of movement without leave, this movement without permission. And for those of African descent and other people of color of the United States, the notion of regulation of movement, the notion of having permission for movement or requiring permission for movement is not so different from the moments of the plantation. So through this talk, I want to kind of weave together a different type of narrative and a different type of story that tells us how law might be considered for those that are considered both in and outside of law. And by that, I mean those that are considered inside of law, insofar as its disciplinary arm, but outside of law, insofar as its protections. So with that, I'm going to go quickly into the PowerPoint, and then I'll hopefully get us into some questions and some back and forth here. So again, the title that we're looking at here, I hope you can all see my screen, is Furtive Blackness. The subtitle, Black Flesh in Presence of Probable Cause and a Reasonable Suspicion. So I want to give you kind of essential definitions because a lot of this is law, other parts of it are critical, Black queer or Black feminist theory. So again, the word furtive is a sly action or of shady character. So it's two parts. It's both verb and it's both noun. So I want to think about that. And I want you to help me think about how that might itself attach or apply to a body. What does it mean to be of a particular type of character innately? But also what does it mean that your body itself foreshadows a particular type of sly or suspicious action, particularly when we're talking about search and seizure under the law. The furtive gesture is oftentimes used as this kind of pretext for police force and stops, particularly when we're talking about excessive force. But beyond stops and search and seizures, I also want to theorize police contact itself. The reasons for that initial contact is kind of the tip of the iceberg of the violence that we're dealing with. Fugitivity is a kind of critical theory concept that deals with this notion of being in constant flight or movement from duty, labor, or law. We hear this language when we think about both the Dred Scott decision and the Plessy versus Ferguson decision, where we're talking about Black folks owing duty or service for life. I talk a little bit about manners. This is coming from Thomas Jefferson's book, Notes on Virginia, where he talks about the sons of slave owners never forgetting how to treat or regard Black freed and slave people. So he actually proposes a particular type of reparations because he says there's always going to be this type of racial enmity that is intergenerational, about an intergenerational memory. Black fungibility, we'll talk about this a little bit, but this kind of notion that Black folks themselves are fungible. They can be kind of mixed up. There is no individual identity. So oftentimes you'll see the officer say, someone fits the description. And we see on the witness stand that 60% of eyewitnesses accounts across race, particularly dealing from white to Black, are incorrect, right? So Black people become easily discardable, but also interchangeable with one another. This notion of the racial hieroglyphics comes from Hortense Spiller's Mama's Baby, Papa's Maybe. It's kind of like the Nike analogy here. You know, the Nike sign on the shoe. Most people understand that means speed. They hear the swoosh sound, but most people don't realize that this Nike analogy comes from the goddess Athena. In the same way that this Nike analogy has kind of gotten away from the notion of the goddess, but keeps her essence, these kind of racial hieroglyphics, Hortense Spillers argue, continue to be present on the Black body, even though Black people are no longer regarded as slaves. She's kind of talking about, in a different way, the ways that Thomas Jefferson's notions of manners continue to live with us. So again, the problem is Black people are rendered furtive. Furtive as far as routine police contact, these violence police counters, in access to public safety and services, and imbued suspicion of criminality. So when I say Black people are rendered furtive, I'm saying that Black people are put in a position of always already being noticed as creating some type of criminality being afoot. It's not only what they do or what we do rather, but it's who we are. And that type of suspicion, that type of assumption renders Black people particularly vulnerable to police encounters, and not just encounters with police and excessive force, but deputized white citizens. When we talk about folks like Barbecue Becky, or we talk about an Amy Cooper who seemed to fear for their lives, even though a logical person outside of a white supremacist gaze sees that there is no danger afoot. The danger afoot itself is Black presence, right, and Black access to the public spaces. We all are familiar with the Fourth Amendment, but we're talking about unreasonable searches and seizures to be secured in your person in your papers. So this is section 1 and section 2 of the 13th, 14th, or the 14th Amendment. So we're talking about slavery here, and we're talking about the abolishment of that, right? But what's important here is we're seeing that there's an exception for the end of slavery, which is being duly convicted of a crime, right? So with criminality already being imbued onto Black people, this becomes a particular type of scapegoat that has an afterlife that allows this criminality to kind of continue. And as we see with the peonage system, the convict leasing system, and mass incarceration today, it allows for slavery itself, or what Saidiya Hartman calls the afterlives of slavery, to persist in Black life. We talked about comportment a little bit. This is just a little bit of history. Dred Scott again, Justice Taney saying there is no Black citizenship or personhood because Black folks are owing service or labor for life. So it kind of be transmutated into a particular type of property, right? That owes yourself to serve another person. And so when we get to talking about this notion of fugitivity, one is oftentimes, we hear this in Negro spirituals, accused of stealing oneself. And those times Black people would say, we're gonna steal away to freedom. So after we have, the end of slavery, we end up dealing with the slave codes first and the Black codes. And these Black codes are important because what we actually see is this kind of unfettered suspicion, surveillance, seizure, and detaining of Black folks. Put easily and put quickly, what we're really talking about is a regulation of Black presence and Black movement, and also Black access to the publics, to the commons. If you go down to the lynching memorial in Montgomery, Alabama, you'll see a lot of they put these reasons up on the wall about someone was lynched, and oftentimes you'll see that someone attempted to sue a white man in court, or they attempted to stop a white man from stealing their cow. So oftentimes these Black codes were not just about restricting the free exercise of Black people's kind of movement rights, but their actual claim to rights themselves. The notion that you can have a right actually is articulated as an offense against itself. So I want to move this conversation of furtivity away from just Black movement, but also Black presence in accessing the public goods and public rights. We all have read, of course, the great book by Michelle Alexandra, which kind of talks about the new Jim Crow and gives us a great birth of data as to where we are in a very kind of succinct and thorough way. But one of the things I did want to point out that in this moment, when she wrote this book, but also currently today, there are more Black men and women, I would note, under state supervision now than enslaved in 1850. And that's something that I want us to kind of hold on to, particularly when we're talking about what's going on in Florida. With this amendment and people not being able to vote due to owning court fines. Michelle Alexandra gives us this notion of sexual profiling. And as we wrap up here and get into the papers, I'll talk about that a little bit. But one of the things she's noting is the Monica Jones case, where Monica Jones is someone who is a Black queer trans sex worker, former sex worker, and was kind of picked up and accused of manifesting the intent by what she looks like, by where she was, by what she was wearing, to engage in prostitution. So again, what does it mean to have this inherent criminality kind of marked onto your body as a racial and sexual hieroglyphic in these afterlives of slavery? The Fugitive Slave Clause, I went over this briefly, but it was a very important moment for fungibility of Blackness within the United States. The reason this was so important, and I don't want to go too deep into Prig, was there was a woman in Pennsylvania, Margaret. She had been let go by her putative slave owner and given her freedom. She moved to Philly. When her fugitive slave owner had died, his sister then sent a slave catcher up north to capture her. He illegally, breaking the law in Pennsylvania, captured her and tried to abscond down south. The Pennsylvania court basically convicted him. The Supreme Court says he has the right to do this, but there's no way to enforce this. It's a states' right issue, right? And so essentially what happens in response is we move from the Fugitive Slave Clause to the Fugitive Slave Act, which essentially criminalizes the not just enslaved people running away, but also white people who might think or might be around someone that they have the reason to believe could be formerly enslaved. And so then white folks in that time were fined what would be $30,000 today and held in jail for a year if they didn't turn in any Black person who could have possibly been a runaway slave. So we then just start to see this kind of incentivizing of the inherent criminality of Black being, Black life, and Black presence. We talked about these Black codes a little bit. And so I just kind of want to run through, and this is a little bit dated now. I just kind of made this PowerPoint a couple of months ago and was updating it, but it shows you how endemic this notion of furtive Blackness is, that the list is so long I can't even fit it on a PowerPoint slide. So in the Michael Brown case, we get this notion of hands up, don't shoot, because if you move your hands too quickly, even though we putatively have a right to bear arms, you might be shot reaching into the glove compartment. Again, this notion of furtive Blackness. With Trayvon Martin, somehow a Black child is transformed from walking down the street, drinking sweet tea in a hoodie with Skittles, to being this inherent threat that is going to overtake a grown adult that has 70 pounds on him, right? And he must be put down in a particular type of way. With Atiana Jones, she's playing her PlayStation with her nephew. Her neighbor calls for a wellness check because her door is cracked open. And instead of asking how she is, the officer shoots her in the head through a side window, right? There's this, and he says he feared for his life. There was a threat. A Black woman playing PlayStation in her own home as a threat. Again, furtive presence. Renisha McBride was dealing with the aftermath of a car accident, her head bleeding. She knocks on a door and she is shocked because the man that's behind the door sees this Black woman and thinks that he is in danger. He didn't open the door. He shot her through the door. And again, we talked about Monica Jones and this kind of walking raw trans and this embodied criminality. And it gets very interesting. We talk about folks that are both Black and queer, Black queer, as I say, because we're dealing with a particular type of sexual violence and racial violence, and they compound each other and they don't happen separately. Because we're in California, I wanted to talk a little bit about Black movement in cars, and you can see the data, it speaks for itself. Black drivers are 65% of stops, while 31% of the population in South LA, right? 28% of African Americans in LA report being stopped as being 9% of its own population, but 49% of the stops. And we see a little bit with this with Latinx folks, which this data is kind of strange because we know Latinx folks are oftentimes also Black and African descended, but it seems like they're slightly underrepresented in this data. But with that, I want to stop there and engage in questions a little bit back and forth, and we can talk a little bit about the articles themselves.
So folks can use the raise your hand function in the participants. Anansi, are you monitoring that?
Yes, I'm going to try as best as I can. There's a couple of screens of people. So
okay. Rule Schiller.
I don't usually like to go first, but I'm interested in your use of history as a methodology, and was wondering just if you could talk a little bit about that. And I guess part of it is when you talk about the contemporary materials, they're perfectly convincing on their own. It seems to be when you're talking about either a construct of Black furtiveness, or even if you're just thinking about how do we revise public policy. And so I'm wondering what's the kind of oomph you get from the historical analysis, or why you use it.
Yeah, so first of all, I think that's a great question. Thank you for that. I look to my work as kind of a descendant, a part of the genealogy of folks like Du Bois and Frederick Douglass, but most importantly, folks like Pauli Murray and Ida Wells Barnett and her work on the Red Letter. For folks that aren't familiar, when lynching was happening down south, a lot of the folks in Congress and in state legislators and white newspapers would say, oh, it's about Black men raping white women. And instead of kind of taking that as fact and dealing with some epidemic of Black folks raping white people, what she did is she went in and started doing investigative journalism, creating our own history to kind of tell a different story. And so for me, the issue, I think a lot of people posit issues today about, reform and this critical moment right now and things are worse than they've ever been. But what I'm trying to do in accounting for history is to posit this thing as an always already moment. To not say that we need to go back to a time when civil rights were enforced. We need to go back to a time of constitutional norms. The constitutional norm is anti-Black terror and anti-Black violence. The jurisprudential norm in history is an anti-Black jurisprudence that begins with someone like Margaret Prigg unable to testify to her freedom because she has no standing as a Black property interest in the United States. So what I'm trying to do is remind us that even though slavery itself in a form has ended, we are living in the wake of that catastrophe. And every movement that we make is still infected by that, right? Our Constitution's infected by that. So reforms in and of themselves oftentimes come from the original ideology that was based in the beginning. And I think about that in the form of that hieroglyphic I was talking about. We don't necessarily say Black people need to be slaves or Latino people don't belong. Well, some people will say that. Let's not. We have a certain president right now. But what I'm trying to get at is sometimes the reasoning for what we're doing, the violence we engage with right now, escapes us because history is so long. I want to uncover these kind of meta languages of law and raciality and gender and sex and make sure that we're actually able to grasp things at the roots. I don't know whose hand went up first.
Ava.
Hi, I guess I wanted to start just by thanking you for this presentation. I guess my question is, you spoke a little bit about these ideas of sort of like the afterlives of slavery, or these ideas of furtiveness that we and the law sort of imposes upon the Black body via white supremacy. And what I'm curious if you could speak a little bit to is, it seems to me that some of the categories that we discuss in our law school classrooms, particularly around issues of search and seizure, are specifically defined around these ideas of furtiveness, right? Reasonable suspicion and things like that. And there seems to be this interesting interplay. And so I'm curious if you have thoughts about whether that's sort of like the white supremacy of the law creating ideas of reasonable suspicion and then that being imposed on the Black body, or what is that interplay between the ways that we sort of define we need reasonable suspicion or whatever that is in order to conduct a search on someone? Is that just we're defining what we're going to see in the Black body anyway, or how are those informing each other?
Right. So I think that like one of the things that's really important to look at, and one of my students, Camilo's looking at this as well, is kind of like the history of policing in the United States, right? We have to remember that policing is an outgrowth of slave patrols, right? And so when we talk about what looks suspicious, what looks out of place, who was probably about to commit a crime, it brings you again back to what you were saying about this definition I'm giving of furtive Blackness, right? And one of the other things that's important to remember, particularly when we're talking about the Fourth Amendment in Terry or Matt, we're oftentimes thinking about how a Black person has been violated by officers, and then the court will respond. Well, if it's a good court, like a Warren court, will respond and give you some limits on what you can and can't do. But oftentimes, the rights that we get come through violations that are oftentimes about a type of racial suspicion that we don't call it that because that's not, that's not good or whatever under law to do explicitly. But it oftentimes comes from these racial violation suspicions. We can look at Lawrence. We can look at Lawrence versus Texas. Most people don't know the backstory, but the person that's featured is Lawrence, but it's really about a brother named Tyrone. Tyrone and his ex-boyfriend were at another man's house, Lawrence's house, for what seems to be drinks and drugs, right? The ex-boyfriend gets jealous that Tyrone is with Lawrence, calls the police, and he says, there's a Black man breaking into an apartment, right? So the racial profiling is actually where we get a lot of our queer rights, right? So, but again, he wasn't a sympathetic figure. He was living with drugs and alcohol abuse and poverty. So the LGBT rights movements of the organization at the time did not want to feature him, and instead featured Lawrence because he was a more sympathetic character. So it's a very, it's a very interesting thing to look at. But this seems to be the history with a lot of our rights, particularly when we're talking about the right to privacy and securities of the body and the home.
Marcus.
Hi, yes. First off, thank you for this presentation and having us have the ability to have this discussion. I really appreciate it. You talked a lot about how history has kind of evolved into this current system that we live in. And, being an African American male within the system, I've seen obviously some disappointing events more recently, especially with the recent Breonna Taylor decision. I'm just kind of curious to see, do you think that there's really an ability to change the system that we reside in currently and have that end up being a neutral system, or do you think that it's inherently going to struggle from the flaws that it's been, consistently dealing with since its inception?
Yeah, I am on the one hand of the school of thought of Derek Bell, when the founders of critical race theory is a racial realist that says, listen, racism is endemic to American society. I don't know if that has to be a forever case. I have not yet seen the changes. And I think, to your point, I think the reason that maybe a lot of these changes don't come in the ways in which we need them to be is because we're oftentimes trying to reform a law that is infected by white supremacy itself. Right? We're not proposing a new constitution. We're not proposing a new reasonable person standard. How can you reform and make an amendment to a central logic that says Black people are 3/5 of a person? Right. And so I think part of it is like, one, we're trying to, kind of put a water out of a burning house. You're going to choke and die from the smoke and embers, right? It's cancerous to live there. And so I think what we need to do is probably build something new, and build something new that has Black folks, non-Black people of color, indigenous folk, women, queer people actually at the table, and not have a central legal logic or public logic of power that is about protecting the property rights of rich land-owning white men, right? And understanding women only as an extension of these men's rights and domain, right? So I think that is oftentimes the problem, is that one, we don't have a long historical education of where this country's been, what it was founded on, what it's about. We kind of romanticize the founding fathers, and we kind of romanticize precedent. And I like to think about precedent itself as the kind of living will, as the founding white supremacist, rapist, misogynist, right? But oftentimes we valorize these people at the cost of people that are still living today in the wake of misogyny, in the wake of slavery, in the wake of the Trail of Tears in these particular types of ways. So I think it has to be a start from scratch. And I think there has to be a deep, deep commitment in this country to understanding and reckoning with our history and making it about ideals and not individuals.
Rory.
Thank you, Morris. I wanted to make a comment and ask a question. The comment is, for those of you who don't know, Anansi is also this semester co-teaching Constitutional Law 2 with me. And at the risk of increasing course enrollment beyond manageable numbers, he will also be doing this again next semester with me, I believe. So if you think he's good in one context, wait till you see Anansi through a whole semester. My question is this, Anansi. Your title, Furtiveness, reminds me of so often victims and defendants and people involved in cases that we teach in areas that are, black letter law principles, whatever. The race of the person is often omitted. The sexuality of the person is often omitted. They're furtive in our presentation. They're furtive in our law. I think of the Armstrong case, which has to do with, selective prosecution, but nobody understands that the judge in that case was a person of color. And that fact has always seemed very relevant to me, but it's not in the case, and it's not taught. I teach it. So I'm just wondering, do you see, I sort of see, but I wonder if you see your concept sort of beginning to reinterpret standard cases that we teach, day to day here in all sorts of areas. It seems to me it could be reinterpreted through the lens that you're presenting us. It just seems so valuable.
Right, and so I'm thinking about Furtive Blackness not just as a way to kind of think about the ascription of Black people in the way that we're positioned in society, but I'm also thinking about it as a navigational system for the ways that Black people avoid and detect search, seizure, and particular types of violence, but also as a reading method, right? How do you begin to read the law from, again, this Black body? And in this essay, I talk about this idea of kind of thinking Blackly, right? What does it mean to kind of read the law through a kind of history of collective embodied Black experiences. And of course, Black people don't all believe the same thing or have the same ideas or feelings, but I want the reader to kind of think about slavery, the Black codes, the slave codes, Jim and Jane Crow, mass incarceration, racial profiling, redlining, the Tuskegee experiment, and then bring that to bear when you read these kind of pronunciations by judges. And to your point, we don't even often know who the people in our cases are. And we don't have a critical analysis of who's in the grand jury and how was the grand jury itself created, right? What happens, we don't even think about like our standards of evidence, what's allowed to be admitted, right? And those things often, very, very often hurt Black defendants and folks trying to gain justice. So yeah, I think that's a really great point. Thanks for putting that out there.
Risa?
Hi. So I'm curious about your work with narrative. When you began your talk, you spoke of the differences. So you said we need to consider narrative differently, how Black Americans especially have been left out of the narrative in one case, but in another need to be within the narrative in order to get some of the law's protection.
Right.
And you also spoke about Ida B. Wells. So as a journalist, she was driving narrative and changing narrative in terms of resistance to Black Crow. Well, I'm curious and would love to hear your thoughts on how can we be training our soon-to-be lawyers now to be driving this new narrative? If we're teaching them the story or the narrative of the law with a casebook method, how can we encourage them to use their own voices with their own interpretations of this long history, or rather integrating more of this long history into how they are narrating our laws?
Yeah, that's a great question. And that's a wonderful question of pedagogy that I've been experimenting with and wrestling with. I had a wonderful professor at Howard Law, Denise Herbert, and she was my teacher of evidence. So I think this is actually a great example. But we get so frustrated about why things weren't admitted. It was like, well, this person's getting screwed. She reminded us that like the law is about proof and not truth, particularly critical law, particularly criminal law rather. And I mean, anytime when you're admitting evidence. But what I got from that was a type of pedagogy where I'm always asking myself and now asking my students, where is the lie? This is the law, but where is the lie? Who was left out here? What is the mode of analysis? And what is the kind of material effect of this argument, right? Not just for this individual, but what does this mean for the country? And then what does this mean for these other groups? And so I think what we have to train into students is to look for the lie. Don't take this case law as gospel. And I think you remember, and many of us have gone through law school and have gone through practicing, know that oftentimes we are trained to kind of memorize, do a rote analyzing, and then repeat, right? Memorize, analyze, apply. Not this kind of like pushing back on what the law is, even in the court. So I think that what we have to do is train our students up to be free to actually question the underlying logic of the law and also make that a requirement. Where is the lie here? And have you found it? And if there is no lie, tell me what the truth is, right? And I think that, at least for my students, that's been something that's been a great catalyst both for conversation and it's allowed them to bring in their personal experience. I think for first generation students, particularly students of color, we have experiences, maybe not necessarily with police, with government agencies, with neighbors, right? That show us a different understanding than what our law professors are telling us. And it causes a particular type of delirium often. I say, wait, you're telling me this is the law, but I know in my body, because I've seen the law, I've seen how it works. So I would say to welcome and encourage those voices in the room, but also pick cases that allow for these deep dives and not just those kind of canonical cases that we often deal with.
Ceci?
Professor. So I guess my question is kind of something that we somewhat touched on in race and sexuality. But to the question of, when we reimagine and we re-envision what a system looks like, that, to your point, kind of like intersectionally considers the compounded experience of different marginalizing characteristics, like you said with Black queer bodies. If we look to that for both the oppressor and the oppressed in terms of the oppression that's experienced, right, both by like you know, what that kind of, those attitudes look like that go into the individual who's committing the violence on somebody else's body and that other person's central experience. I guess I'm kind of grappling with how you hold space for kind of people to be freed to express like their multitudes of beings within that system or within that institution, while also holding space for the erasure that can happen with intergroup discrimination, or, you know, the nature of these things being false dichotomies for people, you know, because of obviously the way that these structures, even as identities that can help to liberate us by being identified with them, can also, you know, commit a form of, I guess, added chaos to people's bodies in the process.
Yeah, and we talked about this briefly. So Cece's in my race, law, and sexuality class. And so one thing this reminds me of is, again, going back to the amazing Hortense Spillers and her work on what she calls intramural violence, right? The violence that happens within Black communities or communities that have been minoritized or oppressed in particular types of ways. And like, one, how do we hold someone's humanity in the type of way that Frantz Fanon may kind of critique, you know, Black skin, white mass, while also noting this kind of intramural violence. And I think that that is a very deep and serious type of community labor that I don't know that everyone is called to, but I think it's an ethical question, right? Like, at the end of the day, it's like, do you believe people are disposable? And then what do you do, right, to make sure that someone is not disposable? But at the same time, everyone has an individual duty to unbecome particular types of systems and practices of violence, of parasitic relating, and different ways of kind of like subsuming other people. So I think that, one, it depends on how close you are to an individual, but it also means, when we're talking about people in society writ large, that we're holding their humanity, right? Because all of us are making choices to engage with or in institutions or organizations that commit particular types of violence, right? But that doesn't mean necessarily that you are embodying this particular types of violence. So I think it's a very nuanced question. And I think it's about a daily political practice and praxis that you move toward throughout your life and commit to. There's a question here on the chat from Cameron. He says, Haiti would appreciate a discussion of the killing of Ahmaud Arbery as it relates to modern day slave patrols, and specifically the responsibility of white voyeurs to Black death. This reminds me a lot of the discussion, not just with Ahmaud Arbery, but also with a brother that was recently killed in the Midwest, about, you know, them kneeling on his neck and people watching, right? So like, how do we begin to kind of think about not just the person who does this type of violence or this murder, this officer that does it, but also those that sit around and kind of like do nothing, right? Or take in the scenery. And that in and of itself reminds me of the old kind of lynching postcards. Oftentimes someone would be lynched, there'd be violence I'm not gonna go back into, but you would see folks having a barbecue or a picnic around it and taking what today would be a selfie and sending these postcards out. So it becomes a communal experience of this particular type of anti-Black violence and terror. And you see that again with the Ahmaud Arbery case, right, where he is chased down by a deputized white citizen who, in their estimation, is operating under the cover of law, right? It's their duty as a citizen to arrest, abscond, and put down this wayward, dangerous, furtive, felonious Black person. And so we see that oftentimes where people operate under the gaze of deputized policing, with, again, Barbecue Becky saying that you can't be here at this park. This barbecue is dangerous. I'm calling the police. I fear for my life. There was no reason to call the police on Black people barbecuing. I don't know what type of public health crisis that creates, what type of fatal violence that creates in her life as she's walking by. But she took it upon herself, right, to what she believed was laying down the law. And that reminds me of Cheryl Harris's kind of understanding or recitation of this notion of whiteness as property, the ability to regulate and profit off of other bodies.
Luis?
Hi, Professor Wilson. Continuing on this thought that you just finished on, I've been thinking a lot about the intersection of law and capitalism and economies. So, you know, thinking about the history of law, especially when it comes to Black bodies, is the enforcement of property rights for economic gain, right? To have this free labor to then increase capital. And I'm kind of curious to hear your thoughts of how you see capitalism and or economics intersect with your lens that you've presented, and perhaps maybe some other examples in history, and even present day, thinking about, for-profit immigrant detention centers and how these ideas of capitalist gain are so entwined with the law protecting gains and capital.
Yeah, I mean, wow, we talked about this a little bit in class. So Luis and my college student class with Professor Little over there. And so one of the things that we marked on is the fact that, most of Black rights, the Civil Rights Act, right, is held up through the Interstate Commerce Clause, right? So like even the notion of like Black access to rights that are enjoyed already by white folks in America, well, really white men at this point, have to be undergirded through a commerce clause, through interstate commerce, the trading of goods and services. And that should tell us a lot, right? But even when we begin to think about the slave trade and when the first Black people arrive here in 1619, and often has a little bit more, sometimes in 1500s, what we see is this kind of the violence of the archive in this redaction, right? So people are noted not by their name, but by their pounds, their worth, their ability to do labor for this many years, the size of their hands, the width of their back, and women their bosom and their ability to reproduce. So when we think about Black folks, particularly, the question has always been about what type of profitability do you land? And we see this both with the end of Reconstruction, the backlash, with the kind of convict leasing and the Peonage Act, and we see this with the vagabond laws, where folks are arrested for standing in a place, for moving in a place, for not being at work, even though they're Black, so no one will hire them. And then they're swept up into prison to work for free, right? And we see that oftentimes today. I mean, people don't want to call it convict leasing today, but what we do see is Black people and people of color at large being arrested in prisons, working 25 cents a day, creating license plates, right? On these kind of wages. Actually, a personal part of that is my uncle is in prison in Kansas. And he was telling me that he works like 60 hours a week. He ends up making $25 a week. Right, and then they take out of his money. That's after they take out gas on the bus, taxes, and also his room and board in prison, which is interesting. But again, to your point around immigration detention and ICE and things like that, again, we see this profitability on people's bodies. And the scholar Fred Moten asks us to kind of think about Black folk, not just necessarily as profitable, but also as accumulation of debt, right? And that debt goes back to the Taney decision in Dred Scott about owing service or labor for life. It goes back to the Federalist Papers in the 3/5 clause, saying you're 3/5 human, 2/5 property, this kind of split interest in the body, right? That even in that way is a political benefit and a political kind of economic benefit, because now the South is able to get more representation, is able to get more tax dollars via the census, just upon Black people being enslaved there, right? And then the final part, I don't want to talk too long about this, is the ways in which the census works today. So when Black people are imprisoned and Latinx people are imprisoned in these southern and rural communities, they still count in the census, right? So the state, that county, that town is able to benefit from the Black bodies held in bondage that they're still asking to pay fines and fees when they leave, and they're not able to vote. They're not able to have a say in the community because they're not seen as citizens, which is very similar to the position that we think about in slavery.
Ascanio.
So, and honestly, your interpretation and your stories are so powerful as a description of 400 years of shared experience. But I'm struck by at least the stories that you're telling today are sort of the experience of individual bodies and being labeled and treated as furtive, which feels like it excludes the stories of Black and Indigenous and other collective movements of resistance. And I'm wondering if that's part of your project as well, and if so, if you could talk a little bit about how it connects.
Yeah, so I think that I'm talking about I'm trying to tell a different story, a story that's kind of untold. I think the story about Black resistance And I think with other non-Black people of color, those stories are more or less often the story that's told. You hear the civil rights movement, you hear about the Underground Railroad, you see Black Lives Matter, and you always, and there's even this kind of romanticization now of Black women with Black girl magic and Black women are gods and all these interesting things that are going on, which is nice affirmations. But what it goes untold there is the kind of insistent harms, right? And so I'm trying to talk about and tell the story about these kind of innovative technologies of anti-Black terror, which I think are not very well understood. And so when I'm not telling the story of kind of refusal, which I think a lot of other scholars are doing really great, I'm telling the story about the conditions that require a particular type of refusal. And so the second paper that I wrote, and we kind of talk more about furtive Blackness, is the strict scrutiny of Black and Black queer life. So the kind of notion of someone being rendered furtive allows for a particular like strict scrutinization of their presence, intentions, movement, and what have you, right? And one of the cases that I actually look at is, I think all of us here are familiar with, is Bakke versus California, right? The holding in that generally comes out to be that if the state of California, right, is going to engage in these kind of policies for like racial justice, racial remedial policies, it has to then show, or the Black plaintiffs themselves have to, the Black defendants have to show, that there is this long history and proof of racial discrimination. Not only there's discrimination, that it has this deep impact. Not only that, but that it's impacted you right now today, right? So the kind of burden then begins to rest on Black people. So even when you're engaged in this refusal, if we're not telling the stories about the conditions of the world, in the ways that Christina Sharp talks about the climate, or the weather rather, being anti-Black, it doesn't matter what house you build if you don't understand the climatologies that you're existing under. So I'm trying to do this other side of the coin, but there are amazing, like fabulous people that are telling stories all about resistance. We can think about books like The Warmth of Other Suns that gives us a very beautiful kind of chronology on this type of work. So yeah, it's a great point, but that's just not my work.
Jody.
Thanks. Thanks so much, Anansi. I think I want to follow up on Ascanio's question, but maybe come at it from a little bit more theoretical perspective. And I mean, correct me if I'm wrong, but it seems to me that your work is grounded in postmodern theory, particularly the work of Judith Butler. Am I completely off base? I mean, I'm thinking of your invocation of the always already that has some real resonance for me in books like Gender Trouble. And so I guess given that, I would love if you could maybe talk a little bit about some of the concepts in there that I think really try and get at the notion of constrained resistance, things like the abject and the notion of performativity, right? The idea that gender is in some sense performed, but it's a forced performance. It's a command performance, right? And so it seems to me that there are some really useful constructs there that might allow you to address the kinds of resistance that Ascanio is talking about, but to situate them within these structures of oppression and coercion that you're interested in.
Yeah, so Gender Trouble and Judith, but I think that's great work, but my work's not grounded there. My work is more grounded in Black feminist theory and Black queer theory. So I'm thinking more about the work of E. Patrick Johnson and the poet I read, Essex Hemphill. I'm thinking about Angela Davis. I'm thinking about, of course, Ida B. Wells and Pauline Murray, the lady that kind of, well, the person that kind of trailblazed and was a great inspiration to RBJ, as we know. So when I think about performance, I think more about the Black queer performance theory. And I think there's a lot of kind of commonality between that, particularly when you're looking at someone like Patricia Hill Collins or Hortense Spillers. But again, my work isn't necessarily to kind of get into refusal in the kind of like the counter hegemon work. And I think it's really important. There is one section of the first article that does get into this where I'm titling kind of Black queer furtivity. And I follow one of my Black trans non-binary friends, Mickey, as she is protesting the bathroom bill in North Carolina. I think it was in 2014. It feels like a long time ago. But essentially, they're going there and they're trying to protest in front of the legislature and gain entrance. And the police and the National Guard are there surrounding them. And it's a bunch of folks in the organization called SONG, Southerners on New Ground. And instead of kind of engaging the police in this kind of violent way or kind of running at them or protesting or even marching, Mickey begins to vogue, right? And she's like a darker skinned trans woman, very thin with long flowing locks. And she just begins to dance and vogue, and the group with her begins to beat their drums. And it's a type of bringing to bear of not just a Black history, when we're talking about the drums and slavery and the ways in which music and song and dance communicate a different type of language and message, but also she begins to bring to bear a Black queer history. She begins to bring to bear ballroom history, right, with the voguing. And so she's telling a story with her body, and she's doing this in a way that makes her story itself both intelligible and unintelligible, right? So if she were to begin to be shouting at the officers, they could say, oh, well, you said this was violent, yada, yada, yada. But instead, she begins to speak from the body. And so in a way, that's one of the ways I begin to kind of talk about resistance and refusal. But I think about it through this kind of Black queer performance theory, as opposed to the ways in which Judith Butler talks about it, which I think is great scholarship. But I think the kind of Black queer history that I draw upon has a different type of knowing and embodied knowledge, particularly via standpoint theory, than the work that Butler does, which I think is still very instructive.
Great, thanks.
Thank you.
I want to give folks a space to sort of gather their thoughts, but Anansi, one person in chat asked for maybe a little more on your papers if you have time and are so inclined.
Yeah, and I talked about strict scrutiny just a little bit a second ago, and I talked about kind of the Bakke case. But one of the other ways I'm thinking about this notion of strict scrutiny, one of the examples that I use, well, two of the examples that I use rather, are the recent, well, I guess last year recent, issue when there was a young African woman that went to Yale. She had fallen asleep in the common room. And one of her, not necessarily classmates, but fellow students at Yale, walked by and saw this Black woman asleep in the common room and called the police. It took about 2 hours for them to resolve the situation. But the officers took her out of the common room, took her outside, of course, demanded her ID, and then didn't believe that she belonged there. And to Jody's point, this young woman goes into a very kind of like defensive pose and a pose of refusal. She said, I don't have to show you anything. These are my books. I'm here studying. It was an overnighter. But in this kind of 2 hour kind of back and forth, we begin to see how Black life and Black presence is strictly scrutinized. Because just on a common sense level, who would be asleep in a Yale dormitory common room with, what I think it was a book from Foucault? Like, that's not, you clearly belong where you are. And so in the second piece, I'm kind of really getting into the ways that like this type of strict scrutinization is a kind of inverted way of dealing with the actual legal concept of strict scrutiny that now kind of requires Black and Black queer people to provide on hand, right? Almost in the ways that you think about papers, freedom papers and slavery, but also papers for censorship for people that are dealing with eyes, their reasoning, right? And their proof of their ability to be present, and the proof in such that they're not a particular type of threat.
If there are no other questions on the papers, I thought I would ask a question on a different topic, but I'll wait 1 second to see if there are other questions on the papers. So Anansi, one of the reasons we have the speaker series is so that diverse members of our community can connect with other people who have diverse perspectives as they think about the law and legal practice. For those of our students and other community members who may be coming at the law from different vantage points than we typically teach in class, do you have any advice on how they can get the most out of their legal education, maybe based on some of your experiences teaching here so far?
Yeah, I would definitely say to trust your experience. I think one of the worst things that students of color and first generation students across race, gender, and sexuality end up doing is supplanting their experience with what they're taught as the law. I think the best way to understand the law is to put the law up against your personal experience. memorize that law, analyze that law, understand how it's written and how it's applied, but also understand the gaps and the contradictions that your lived experiences, and those are the stories of your mother and your grandmother, and that's what you've seen in your community, how they collude and collide with each other, right? Because I think that in the collision, in the rupture, you start to really get a great understanding of what society is actually doing and what it's actually like, and it imbues you with a particular type of toolkit, right, to not only survive law school without too much sleep deprivation or going crazy and being depressed or, leaning on other things, alcoholism and other things, but it allows you to kind of leave law school with the toolkit to be a type of social engineer, to change the ways that law is seen as canon and kind of these kind of traditional viewings of it, to change it in a way that actually sees you as human and gives your life and the life of those that you care about actual standing, right, in order to be considered.
Thank you. Are there any other questions? Mila.
Oh, wait, can you hear me?
Yeah.
Okay, there we go. Thank you for this wonderful presentation so far and conversation. I wanted to ask about broadly, as we can tell, there's so much structural and individual backlash and challenges that people of color and specifically Black communities have to face on a pretty consistent basis when we are engaging in everyday life. Sorry, my phone's about to die. It's on 1%. I'm trying to plug it in. But as we're engaging in these conversations with, our peers or our communities that don't have the same exposure, I'm interested in wondering about how you approach, these conversations with an eye for longevity when you don't want to have the burden of, all of these systems come crashing down on one, token representative. So I'm just wondering how you engage with non-Black communities or allies that are interested in understanding these types of issues further.
Sometimes I don't. I think it's that simple. I think that oftentimes, particularly those of us that are just coming into consciousness about our history or about putting ourselves in kind of long conversation of time, is it for people of color and queer folks and women and femmes and trans folk, immigrants, we often think that for the movement for freedom and liberation and equal justice, we have to do everything. We have to have every tool, and we must be an expert in wielding every single device in the fight for justice. Listen, some of us are scholars, some are creators, some are artists, some are organizers, some are storytellers, some are doctors, healers, spiritual advisors, and some do this work of translating the Black or queer, what have you, experience to other folks in order for it to be both palatable and understood. I think you have to understand what your role or roles are, and also take it day by day. If you're tired of having these conversations one day, don't have it, because you have to realize that your body itself cannot be a chalkboard, whereas lessons of comportment and understandings for other people are scribbled and scraped onto. So I encourage you to always center yourself in your care. And again, there's this book I told you about by Professor Sharp, In the Wake on Blackness and Being, that centers this notion of not just self-care, but care work. And so I think you have to have a sustainable practice of care work and know when your body, your mind, and your spirit are saying, wait, this isn't my battle. I can't do this today. And also one of my favorite things to do is to send a reading list or Google. A lot of the things that people ask you about, they can easily Google, but people think that because you have a certain identity, that it's your duty to teach. Remember that you're not a professor, you're a law student. So send people to Google sometimes or send them a reading list.
Professor Wilson, thank you so much. Thanks to everyone for joining us today. And Professor Wilson will stick around for a few minutes, I think, but we'll end the recording and the YouTube live stream now. Thanks for everyone.